webinar. Okay. So if you're scared, you have to tell us now.
Are we on, Madam President?
We are on. People
Are we
joining
expecting one more panelist?
Who's missing? No. Bobby?
Yes, I'm here.
Oh no. Dr. Osgood, that's true.
Yeah.
Let me see.
Hold on.
Let me check and make sure she's not over with the attendees.
Are the graduations over yet? Because between her and Dr. Wanza, I'm telling you, they were everywhere.
That's true.
That's every year, Judge. Her and Dr. Wands will be everywhere. Listen, and this is the first year that I haven't been everywhere. But it's an exciting time. So I took a break this year because next year it's gonna be live and direct. I got a rising senior. I got a call today, the recording. Your child is now a senior. I was like, I told the recording, you hush your mouth. I was like, I'm not ready. No.
Okay. Ethan is a senior? Or
Ethan,
your bonus son?
yes. No, Ethan.
Ethan.
The senior
Ethan.
already? Oh my
Yeah.
gosh.
And Judge Holmes, yeah, because he's actually he's the team president for Jack and
I
Jill.
saw that.
Yeah,
That's
yeah.
awesome. We'll see you there this year.
Yeah.
They grow up very fast.
Well, Judge Holmes, I will tell you that your husband is going to the second grade.
Well,
Jacob.
That's good. I want to make sure y'all still feed him. You know, he's on loan to you. That's my future
he is
ex-husband.
growing. He is so tall. The doctor told my wife, she said, this one's gonna be tall. And she said, I know his dad's tall. His dad's 6'3". The doctor said, no, he's gonna be real tall. And I was like, when did 6'3" become not tall? So Jacob is growing. You're gonna have your tall one.
Is he like basketball?
He's in the soccer right now. He's 7. So I think Malik's gonna introduce him to basketball.
7-foot people out there kicking that ball.
He's a 7-year-old at heart, but he does look like he's about 9. So,
well, I love him. That's my future ex-husband.
Your future
ex-husband.
Oh man, that's funny. And Bacardi, how are the kids?
Oh, everybody's doing great. We were happy to get through a year at home.
I know we did a year at home. You're happy, Yvette's so happy that Jacob is going to summer school.
Wow.
But it's been a challenge, you know, especially with the boys. Ethan's done well, but Jacob being in first grade and being home, and we've done a lot of stuff. We did Kuman on top of it. It's just, you know, the maturity and the not being, you know, in a classroom. I really see the difference. You know, there's, you know, boys are just different.
Yeah.
Tell us.
And on that note, we are going to get started. Dr. Osgood will be joining us later.
Okay.
She is actually double booked. She says that they are in an executive board meeting. So.
Oh, okay.
Okay, we're gonna do this. And I don't see Minister Edwards, so if we Judge Holmes have many tasks.
I'll be more than happy to.
You
Father,
will
we
open
thank
up,
you
please.
tonight for this meeting here. We thank you for those that are assembled here. God, I ask that the information that we receive tonight be absorbed into our hearts, into our minds, that we do better for our children. Bless the speakers, the presenters. Bless everyone that's involved with this gathering tonight, our participants and the attendees in the audience. And then God, I ask you now to give us strength, keep us well. And this we pray. Amen.
Amen.
Amen. My name is Marsha Ellison. I am president of the NAACP Fort Lauderdale branch, but tonight I'm wearing my Florida State Conference hat. I serve as the chair of the Civic Engagement Committee for the NAACP Florida State Conference. I certainly bring you greetings on behalf of our illustrious president, Anamadora Obianweze. She sends her sincere apology. She was not able to make it this evening. However, She didn't want our units to go another day without receiving this information and getting ready to do our action alert to make sure that we work very hard to save our children. And with that, I want to introduce to you all and reintroduce to some our own general counsel for our branch, retired judge, but she'll always be a judge to me, Alona Maxine Holmes. She works with us on a daily. She often says she works harder now than she did when she was on the bench, working with the NAACP from our state level and our local level as well. And it's a full-time job, keeping us out of trouble around here, but she has keeping us out of bad trouble, but into good trouble here in Fort Lauderdale, Broward, and within the Florida State Conference. And with that, Judge Holmes, you have the floor.
Thank you, Madam President. It's an honor to be here tonight, and always an honor to be in the presence of fellow NAACPers. And tonight is a special evening because we have some special guests that have done some special things regarding our children. As you know, that the theme for these events have been save our children. And that's what we're trying to do. And every time we turn around, there's something new. Tonight, we're going to be discussing Florida's Baker Act. Many of you have heard about it, but you may not know about it. So we're going to have some experts from the Southern Poverty Law Center. It is my esteemed privilege to tell you a little bit about our presenters, and then they're going to unmute, and then they're going to have the floor. They have a presentation for us. I want to first begin with Ms. Bacardi Jackson. She is a senior supervising attorney for the Children's Rights Practice Group, and she is the managing attorney for the Miami office of the Southern Poverty Law Center. The Children's Rights Practice Group focuses on stopping the school to prison pipeline, ensuring access to mental health services, and ensuring that there is equal access to education. Ms. Jackson is a graduate of the Stanford University and the Yale Law School, and she's a proud mother of 3 children, and she is glad to announce that they are attending public schools in Broward County. We also have Mr. Sam Boyd, who is a senior staff attorney in the Children's Rights Practice Group in the Southern Poverty Law Center's Miami, Florida office. In that role, he has investigated the use of the Baker Act on children across Florida for more than 2 years. He also co-authored the Southern Poverty Law Center's recent report on the topic, and he advocated for legislative reforms. And prior to joining the Southern Poverty Law Center, he was an attorney in private practice and a judicial law clerk. Without further ado, Ms. Jackson, Mr. Boyd, if you're unmute, the floor is yours.
Thank you so much, Judge Holmes. It is a pleasure to be here with you and everyone. Thank you for having us to talk about this issue that has been weighing heavily on us for the past couple of years as we have been looking at it. It came to our attention through a number of folks who work on the ground and work all the time representing children, and quite disturbing information about it. Sam, I think you're going to share slides. Are you able to? Okay.
Yes, I think so. Just a second. Can folks see my screen?
Yes.
Yes.
All right.
So as mentioned, we have been working for a couple of years on this issue, and one of the reports we just completed with the help of stakeholders from across the state. We talked to organizations that work to represent children. We talked to young people who had graduated out of foster care. We've talked to parents, quite a lot of psychologists and psychiatrists and experts in the field, educators. We have really tried to make sure we have a full understanding of the issue before us. And so we were happy to produce this report with quite a number of co-partners who you can certainly check out the report, and I'll drop a link in the chat. I think I just dropped a link in the chat so you can click on it and check it out at your leisure. But it was a daunting task to understand the data and especially to hear the stories of so many parents and children who have been traumatized by the Baker Act. And the Baker Act, for those who don't know, is the Florida Mental Health Act, which is the statute for involuntary examination, psychiatric examination. Many of you may have heard about this case from 2020. It was one of the more notorious ones with a 6-year-old Nadia King, who was arrested, and it was quite dramatic video footage of seeing her being put in the back of a police car, and even the police officers showing an incredible amount of disbelief that this child was being sent to a receiving facility. And just to give you a little bit of flavor about what this is, it's not just some innocuous thing that happens to children so we can control them or get them back under control and they can get help that they need, which is how it's often spun as proponents of using this in Florida. It is literally taking children sometimes as young as 5 and 6 years old, like Nadia, putting them in handcuffs, putting them in the back of a police car, and transporting them to a facility where they know no one and often are not able to speak to a parent or family member, sometimes for a full day, overnight. Sometimes it's their first night ever being away from their family and spending a night somewhere else. It is deeply, deeply traumatizing. It's traumatizing for adults who go through this process. So for children who are that young and who don't have a full concept of what may be happening to them, it has consequences that last for a really long time. One psychologist said when parents have the resources, kids don't go back to school for 3 or 4 months. Unfortunately, most parents and families who get caught up in this don't have that choice, and the kids have to go back with all of their fears, all of their anxiety, worried that they're going to be taken to jail, as many of them perceive this process to be. Oftentimes they are housed with older children or children who have all kinds of things happening. It is a very tough process for all of the clients that we have talked to. Next slide, please. And the numbers in Florida are astounding. The rates that we have seen children being Baker Acted here are on the order of about 37,000 every single year. You will hear reports, maybe a recent number that came out that it's a little bit lower than that for the past school year, but we also know that we were out for COVID. But generally speaking, this is, and even with that, the rate that we were moving in the year would have been the highest year recorded ever if it had kept going at the rate before students were out of school. So this has a huge, huge impact. And we have seen an increase in the number of kids Baker Acted by about 5% every single year. From 2001, the percentage increase has been 152.6%. In the number of children that we have seen Baker Acted. So we like to, think about what is it that's probably causing this kind of drastic increase. And one of the things that has corresponded with it, which you can probably already predict, is that we have had this constant growth of police in our schools. We have seen the reactionary response to tragedies where we have put young people in contact with police constantly. That has now become a first response for teachers who have children that they don't know how to handle or who are just causing problems and need to get out of the classroom. But these, again, oftentimes are children who are either demonstrating normal childhood behavior, children who are exhibiting symptoms of a disability, or children who are being punished for some reason. And so we have been especially concerned about the fact that it has a disproportionate impact, as does almost every kind of an exclusionary discipline that's used in our school system. We see that the rates that our children are being Baker Acted are about twice for Black children as they are for their white counterparts. And when you're talking about even younger children, it's even worse. And I think Sam will get into some of that, but I'm going to turn it over to him to talk to you more about some of the specifics of the statute and how it works and some of the things we are now doing about it.
Thanks, Bacardi. And I should say, definitely also, key leader on the report that we published and linked to. The fact that I was mentioned is in no way meant to exclude her or the many other people who were extremely instrumental in getting that published. So we really appreciate everyone. If you would like to take a look, we'd like it. So yeah, I'm going to talk a little bit about sort of exactly what the Baker Act is, because there's a lot of misunderstanding and failure to sort of get the details of that among not just members of the public, but also law enforcement, schools, and even sometimes mental health professionals. So I'm going to explain a little bit about what the Baker Act is, how it works, and then we're going to talk about a specific example of how it's used in Palm Beach County. So every state has a statute that allows short-term involuntary examination or involuntary commitment of people with mental illnesses or sometimes other conditions who may be a danger to themselves or others. So when people don't have the capacity to make decisions for themselves, and when that lack of capacity endangers them or someone else, the state can, in limited circumstances, step in and evaluate them to determine if, in the unfortunate circumstances, they might need longer-term involuntary placement. So the Baker Act is meant to be a short-term placement when a psychiatric facility can examine someone and determine if they need to go to court to see if they want to hold that person for a longer period of time in their interests or in the interests of others to protect them from violence. So importantly, in Florida, this can only be done under the Baker Act, at least, when someone has a mental illness. So it cannot be done when someone is just dangerous for other reasons, when they're dangerous to themselves or others because they have a developmental disability, or just because they're being violent or self-harming. It's really only when someone has a mental illness. And that's important because we actually have different procedures. So if someone has a drug or alcohol problem, there's a separate statute called the Marchman Act. If someone has a developmental disability, there is a procedure for institutionalization. That's generally not advisable, but it can be done in extreme circumstances. But that requires a prior court hearing because it's not like an emergency. So you have a right to go to court first. And when I mention that, because often this first step is ignored. So when schools initiate Baker Acts, they often just go straight to, is someone dangerous themselves or others, without asking, do we have reason to believe that the person has a mental illness? Second of all, they need to be unable to understand the need for treatment or refuse treatment, which in kids' case, we don't expect them to make those decisions for themselves. So that's sort of red for kids usually. But then either they're unable to take care of themselves, which again, for children, that's important for adults, but for children, we don't expect them to take care of themselves, right? So that's not really a basis to, at least it shouldn't be a basis to confine them when they're not able to do something that they already are not expected to do. And then sort of the final prong here, which is the underlined and highlighted portion, is what's usually cited, and what's the sort of the key meat of the Baker Act besides the mental illness requirement, is the requirement that someone pose that there be a substantial likelihood that without care or treatment, the person will cause serious bodily harm to himself or herself or others in the future, as evinced by recent behavior. And so I emphasize all these elements of the statute, partially because I'm a lawyer, right? And I care about the details of statutes, but also because we really see when folks talk about the Baker Act, when they talk about their decision to use the Baker Act, they often leave out a lot of these really important requirements. You'll see someone say, well, we had to use the Baker Act in this case because this child has been talking about self-harm and that's serious. And they'll leave out the fact that the child has been saying, I've been feeling sad for months, right? And that's a serious condition that should be treated, that should be addressed. But it's not the kind of thing that requires a 72-hour hospitalization immediately, right? That's something that, maybe you can go home, you can make sure that that child's safe, you can take them to a psychiatrist the next day, you can provide a less restrictive, less traumatic, less harmful series of interventions for that child if there isn't the immediacy that the statute actually, in fact, was written to require. And then also there's this requirement of serious bodily harm that's often also lost in translation. So we've seen kids who are Baker Acted for threatening to stab someone with a plastic fork, for scratching their wrist like with their fingernail, right? That's described as self-harm sometimes. And the statute says serious bodily harm because it's a really severe restriction on someone's liberty to hold them in a psychiatric facility. And it should only be done if it's really necessary to prevent the kind of harm that we really need to prevent, right? And so, I think there's someone in the comments asking about children having tantrums, and that's, absolutely the kind of behavior, and I'll get into this a little bit more in a second. that's the behavior. Teachers basically, maybe they don't know what to do with the kid. Maybe the kid has had tantrums before and the interventions they've tried haven't been effective. And so they go straight to the Baker Act. There was a recent incident that I can talk about a little bit more later where exactly that happened. And so I talked about mental illness a second ago. It's important to understand that the definition of mental illness under the Baker Act excludes developmental disabilities like autism. And that's really important because a huge number of the kids that we see who are subjected to involuntary examination under the Baker Act do have autism or are on the autism spectrum, or they have other developmental disabilities. Like, so for example, ADHD is generally considered a developmental disability. And that's important to understand, first of all, because it's just illegal to apply the Baker Act to those kids. And then also because really a psychiatric facility is not a good place for a kid with autism, in addition to the sensory processing issues they might have, which are probably going to be exacerbated in an unfamiliar setting like a psychiatric hospital. There's just not a lot that a facility like that can do for a child with autism who may be having, a meltdown, and maybe having a emotional regulation problem, but that's not going to be really made better by being confined in the facility for a short term. And often it's those kids' parents who are best placed to, or guardians, who are best placed to deal with that situation. And that's exactly what they're being denied the ability to do by police or schools. So Baker Acts can be started by medical professionals, police, or courts, although the courts are pretty uncommon for things to start that way. So usually what happens is either a medical provider sees someone, determines that they're a danger to themselves or others. That's about a third of the Baker Acts, or about 2/3 of the time, it's a law enforcement officer who's initiated the exam. And so the other thing that's important to understand about this is that this can be done in the case of kids, at least in practice, without parental consent. So I put up some language from the statute on the screen. I think it means that parents are required to consent, right? Express and informed consent for admission or treatment of a patient shall be required from the patient's guardian. Unfortunately, that is not how it happens in practice, as some of you may know. We have interviewed, dozens of parents who have said to schools, have said to receiving facilities, I know how to deal with the thing that my child is going through. Let me take them home. Maybe they think the child needs medical care. In some cases they do, in some cases they don't. But he'll be safe with me at home. It'll be less traumatic. I'll make sure they get the care that he or she needs. And facilities and schools and police have said, no, we're making that decision for you. And we think that's, not what the statute actually requires. And it's also not constitutional in our view. Parents have a constitutional right to make decisions about the medical treatment of their children. They have constitutional right to the care, custody, and control of their children. And yet they're routinely denied that right in Florida by staff, by police, by schools, and by the whole system, frankly. And that's not to say there aren't sometimes extraordinary circumstances where parents' rights can be taken away. We have a child welfare system for that. There is also, mechanisms if you have a child who, whose parents are just for whatever reason not appreciating their medical needs, or certain cases there's religious disputes, and there's processes by which a judge can intervene to deal with that. And there's also genuine emergencies, right? If a child's out and is in a car accident, the emergency room staff can provide medical treatment, but they can't do it if the parent is there and saying, no, and there's some time to think about it and go to a judge if the emergency room staff disagrees with the parent, right? We think that for all other kinds of medical treatment, we think that parents are the ones who ultimately get to make those decisions, absent, like I said, extraordinary circumstances. And yet when it comes to psychiatric care in Florida, we don't do that. And at SPLC, we think that's wrong, and that's something that we're working to change. So a little bit more here about the sort of the mechanics of exactly how a Baker Act happens in school, because we focused on school because something like a third to a half of Baker Acts are initiated when kids are in school. So a child has a behavior that leads someone there to think that they're endangering themselves or others, or at least to think that something must be done. The school staff may contact a mobile response team, which are sort of meant to be emergency care providers who can determine whether Baker Act is necessary. Unfortunately, what we've seen is those folks often don't have really extensive training. In some cases, their recommendations are ignored. We've seen cases where kids are Baker Acted, over the objections of the mobile response team. We've seen cases where they're not contacted. We've seen cases where they're contacted but don't really seem to be doing much in the way of systematic review of a case. But whenever case, it's ultimately, in most school districts, usually the police make a decision, which from our perspective just doesn't really make a lot of sense, right? You have medical professionals, on staff at most schools, and yet they're not being allowed to make those decisions about the medical welfare needs of the children in the schools. So once that decision to Baker Act is made, they are almost invariably transported to a receiving facility. And when I say receiving facility, that's just a psychiatric hospital or inpatient psychiatric facility, not either attached to an ER or not. And they're always transported there in a police car, usually in the back, almost always in handcuffs. It's almost always a marked police car. And so for a child, especially for a young child, that's an experience very much like being arrested. And some of the kids we've talked to will say to us, right, I don't want to go back to jail, by which they mean the Baker Act receiving facility. And so that, I think, really draws, makes clear, right, the harms that this has to kids, which I think, a lot of people in the system in good faith just are not thinking about. So once a kid gets to a facility, the facility either has a psychiatrist on staff or doesn't. Most of them have psychiatrists on staff, but only like in the mornings for a short period of time. And at that point, once the exam has been initiated, if there is a psychiatrist on staff, the psychiatrist can say, either I think they need to be there, or I think they don't, and they can let them go. But if there's not a psychiatrist on staff, the child cannot be released until a psychiatrist gets there. So that means a lot of kids are Baker Acted out of school. The facility thinks, I don't think this kid needs to be here. This is not a problem. And yet the facility is not legally allowed to release them until the next day. And so that's a problem that we're again trying to change through legislation and also through advocacy. And so, if a psychiatrist does feel they need to be there, they can be held for up to 72 hours under the law. But also in some cases longer. So the statute says that they can be held until the next court working day if that 72-hour period ends on a holiday or a weekend. So that can be 5 or 6 days in some cases. And then if the facility petitions for a longer-term hearing, a longer-term commitment, the child can be held until that hearing occurs. And there are some facilities, from what we've seen, that do petition for a lot of kids, and they drop the petition right before the hearing, allowing them to hold children for even longer. That's definitely a minority of facilities, but it does happen. So I know I'm going a little bit long, and I apologize. I will speed up a little bit. So Florida is also an outlier in its use of voluntary psychiatric examination. It does it more than 10 times as much in many other states, and it's higher than any other state for which we have data. This is all in our report if you want to dig in more. It's gone up, as Bacardi said, dramatically since the 90s. And then really quickly, here's a sort of case study we did of Palm Beach County, which collects good Baker Act data, to their credit on how they use it. It's gone up dramatically over the last 4 years from about 250 to what would have been more than 400 had they continued at the rate that they were going in the 2019 to 20 school year before the pandemic shut everything down. There is, as Bacardi also said, really dramatic racial disparities. And I should say these disparities actually to some extent understate the problem, because especially for older kids, the Baker Act is sometimes viewed as the nice thing that police can do. And so they might Baker Act a white child and arrest a Black child in our experience. And we see that particularly for really young kids, because they're, so 59 5, 6, and 7-year-olds were Baker Acted by the Palm Beach County School District over those 4 years, which I just presented data, and 40 of those were Black. So for those really young children, I think they're being seen as older, they're being seen as more aggressive, they're being seen as more dangerous by police officers and school officials. And that's what's driving this, extreme racial disparity for the population that is most vulnerable to this harm, right, which is the youngest children. And this is all in a district that's, as I said, only about 28% Black. So there's also some age differences. So younger kids are usually Baker Acted for, at least in the data we've seen in the police reports we've reviewed from Palm Beach, for kind of outwardly disruptive behavior, acting out, throwing a tantrum, as someone said in the chat, hitting another kid, right? Which is not good, but it's not danger of serious bodily harm typically. Older kids, it's more self-harm, it's more suicidal statements or ideation. And in some cases those are very serious, but in most of those, short-term involuntary hospitalization is not going to be either helpful or necessary. So again, this is a quote from one of our clients, with which I'll end. Just because I think it's really important to understand, I think a lot of people see this as a way to get help for kids. They see it as either they can't convince the parents that in their minds that care is necessary, or they just don't know how to get a child care and they think, I'll just do the Baker Act. That's a solution. And I think what we really are trying to drive home to folks is that, and there's research on this, which we cite in our report, that is more often than not a negative experience for children. It makes them afraid of law enforcement. It makes them afraid of seeking mental health care in the future, right? Because they're afraid that this terrible thing is going to happen to them again if they're honest with their mental health care provider. And it just fundamentally does not succeed at the essential goal, right? Which is to get the kid help, right? So you go in for 72 hours, you're let go as a child or an adult. There's often no follow-up care. It's sometimes disruptive to existing medication regimes. It's disruptive to existing treatment plans, and it's just traumatic, which is often not a good thing for a child who's already even in the case of a Baker Act that is somewhat justified. Already a child's gone through a lot, and then you've added another thing that makes things worse. I mean, so many of the kids that we've worked with, maybe they were dealing with some stuff before, but after the Baker Act, the main subject of their treatment plan is how to deal with the effects of the Baker Act. So, I could talk about this for a long time, and I probably have already done too much, but I'll hand it back over to Bacardi.
Yeah, so just but again, invite you to take a look at the report if you want to know more about the details. But what I wanted to just highlight quickly is that we are working on this issue from several different lenses. We have been working trying to develop legislation around it. We've been pushing for legislation for the past couple of years. One of the solutions that we think would make the most sense is to have separate provisions related to children that are different from the provisions that relate to adults. And we have, tried to introduce that. The other things that we are doing is we're looking at litigation options. Right now, we're focused on Palm Beach County, but we're also looking at receiving facilities. If you know people in Palm Beach County who have had to deal with this, we'd be happy to talk with folks. And we're also doing, community advocacy, education, and organizing. So feel free to reach out to us if you have more questions, and we're happy to take questions here as well. So thank you. Thank you for the time to present.
Okay, we're going to ask folks to put their questions in the Q&A. And while you're doing that, one of the things that Attorney Jackson talked about was working with our state legislators to make sure that we move the needle on this piece. And so one of our NAACP peers, one of our longtime advocates that work with us on a daily basis is Representative Bobby DuBose, and he is currently the leader of Democrat House representatives there, the minority leader. And so I wanted to have Representative come on to talk about the bill itself. That I know this is the first time I see that the bill's 50 years old, and this we moved the needle a little bit, but not enough. But I want to talk about how we even were able to get what we did get this year. And so I've asked Representative DuBose to come on and share with us from a legislative perspective where we are and where he can help us get to on this legislative bill. So Representative DuBose, you have the floor.
Thank you, Madam President. Thank you, Bacardi. Thank you, Sam, for your work that you're doing. I think Madam President kind of hit the nail on the head as it relates to this, not only this bill, but the legislative process. The SB 90, where you find the language around the Baker Act, is a step in the right direction. As Bacardi pointed out, there's more that needs to be done. But, I'll just always be upfront about this process in Tallahassee. It's very fickle. And so sometimes the process puts us in a posture where we have to start by getting something on the books so that we can move forward from there. And that's what happened. I mean, we would love to have had where the language talked to getting permission from parents as opposed to notification, and we can kind of go into all of that. But it's a first step. I think Judge Holmes in her early introduction talked about legislation and statutes. And so, and I want to take this moment to kind of highlight the importance of not only getting, legislation on the books and the statutes, but it's about who's interpreting them as well. So when we have a full conversation around issues, especially relates to kids, that's very important. I think Sam pointed out something that we need to address moving forward as well. We need to distinguish this act as how it applies to adults as well as children. There just needs to be bifurcated, and there's no clear lines on how that's addressed. So I will say this, moving forward and taking this report and taking this partnership here with the Southern Poverty Law Center, as well as the NAACP, is really what it's all about. I can tell you this last session, working closely with the NAACP and moving forward on major legislation, this is the right posture. We need to start early. We need to start with this discussion. We need to start to educate folks. And I can tell you my capacity as being the minority leader in the House, and you can take me for more than my word. You can look at the last session on these same issues. This will be a priority. We will file legislation. And that's the other thing too, being able to take an issue and take all our stakeholders, putting in the work ahead of time, and what we're doing is really how this process works. And so we're at the beginning of, we have legislation on the books. We're now educating, we're out now putting the stakeholders together, and we're putting a strategy together. And then when we go back, we start committee weeks in September. The work never stops, although we just came out of session, but this is the prime time. And I can tell you, as the minority leader in the House, we will make this a priority. We will file legislation. We will work with our allied partners, you all, and we will use the same model we used before, which was very successful. Now, I will say a lot of times our strategy extends beyond just legislation and getting a bill passed. Sometimes we work together with you all to put it in a proper posture, because eventually we may have to take it to the courts on a lot of these issues. When I hear the reports, and you guys did a phenomenal job, Sam and Bacardi, but I can't help but to think about my own kids. I have a 7-year-old, and I just can't even imagine, we're talking about how big he is and, how he looks like he's older than what he is. And he's a young kid. And when he experiences things, trauma is trauma, and it doesn't go away when you get 15 or 30 or 50. We're all probably still dealing with some type of trauma, something that happened. So whenever we can do what we can to prevent our young folks from having any experience of trauma, this is the time in their lives when they are like a sponge. They're taking in all the positives so that they can live a positive and healthy life. And so when we as adults and stakeholders and legislators are not doing our part, are putting, laws on the books that will have an adverse effect on them, that's something where we got to stop and pause. So I'm thankful, and thank you all for your work, and thank NAACP for putting this together. But this is just a step in the right direction. Again, the law that we had didn't go as far as we wanted to, but I tell people in this process, probably the hardest thing is to get something on the books. It's almost like cracking the door open, and that's what we've done. And now we really got to put in the muscle and continue to work, and so that we can protect our young kids. And also, I think just highlighting the disparities here, how this disproportionately affect kids of color is something that's paramount. And how, again, I was reading the report, and this is just almost like a gateway to the school to prison pipeline. There's so many things around. When you hear Baker Act, it doesn't sound as harmful as people think it is, because I think most people have their experience with Baker Act is with adults. And then also just not even understanding, what it means and the criteria too, and people are using it. And just another point I'll highlight, and I know we have our school board chair on here on the education piece she probably can speak to, but just in general, I've learned, raising 4 young Black men, and the school system treats and sees them differently. I have a son that's going into his senior year. He's highly intelligent and he's highly vocal. And that has been a problem that I had to always show up to be there, because at times they wanted to shift that to something that was more behavioral than just his curiosity and his learning and not being challenged. So I throw those all out so that folks can see, this is a bigger picture. This is more than just a law going on the books. This thing has an overreaching effect that it could just have a continuous long-term and negative impact. But Sam, I did have one question for you before I turn it back over to Madam President. I think you were talking about Florida being 10 times higher than other states on that particular slide. Is it just safe to say that those numbers are also reflective of how it's disproportionately applied to children of color in those states?
Yeah, I don't know if we have race data for all those other states. I mean, I would be surprised if it's not racially disproportionate everywhere to some extent or another. But I don't have other race data outside of Florida, unfortunately.
Okay, thank you. Madam President.
Yeah, thank you. Representative DuBose, now, you are seeking higher office. And so we were going to be needing someone to file the proposed changes to a bill or bills. So what's the timeline for getting that information to you? I think someone said you all go back committee meetings September, something along those lines.
Yeah,
So what's the timeline, and what happens when you have gone on to your next phase? How do we continue this fight, and how do we make sure that gets bill filed, that we get sponsored, and somebody's there to fight for it in next year?
Excellent question, Madam President. The good thing about being the leader, you can help set the agenda. So we start committee weeks, and we can start filing our bills. And this is one, after working with you all to shape the legislation, we can file that bill. I can assure you that I won't necessarily file the bill because, one, I won't be there. And plus, typically leadership doesn't, although I did this session, doesn't really necessarily file bills. We kind of follow them. I will say the great thing is that, for example, my policy chair, who is a future leader designate, and Representative Fentress Driscoll, who will be the first Black female to lead our caucus. I throw that out there because I think that's very important. Because I always tell people, if you really want to get something done, you need to get a Black woman to do it. But that's my bias because I was raised by one. And so I can guarantee you that we will have this legislation filed. It will be a priority, and there will be a member of the caucus that will still be around after I'm gone in January to make sure. But the bigger thing, the point that I want to make, regardless of who files it, the fact that this will be a priority for our caucus is the very important piece to this. And also the fact that we are working with our ally partners. This is the same method that we took when we took on HB1, the anti-protester bill. This is the same method that we took when we took on SB 90, the voter suppression bill. We've worked with our ally partners, and on your end, Pamela Birch-Ford was amazing. And we will continue that same vein. And now that we've gotten through our part with that, because I always look at these issues in Tallahassee as a long game. As I mentioned before, sometimes we work with our partners to get it accomplished into law, but if not, get it in a proper posture for the courts. So I can tell you that we will continue to do what we've done with you all on all these issues, and this will be treated no differently.
Thank you. We talked about schools being the pipeline. pipeline for a lot of things, and unfortunately, not too many bad things. And I know that that the numbers that we're highlighting, um, Palm Beach County, but Broward County always has stuff going on, and we certainly have a champion there who works with us. And I hope that she is able to get on our own school board. She is our chair, certainly a fearless leader in Broward County, and it's so unfair to her that she has a district. She's not the at large, but we all treat her like that because everybody all over the county calls Dr. Osgood for their problems, and she answers the phones. And sometimes she'll say, well, actually, I'm not your school board member. And we say, okay, thank you. And then we go on and tell her what our issue and our concern is, and then she addresses it. So, Dr. Osgood, are you able to get on? I know she's multitasking here. The problems that are in our schools, and I know it's not just we're talking about across Florida. It is just endless, and we are seeing superintendents come and go. We're seeing leadership come and go, and it has just been a messy. But we always have to have a champion who continues to stand in the gap for us, and that person for us is our own Dr. Rosalind Osgood. So, Dr. Osgood, you have the floor.
Thank you, Madam President, and thank you to all of those that presented tonight to our community. It is always an honor to be with the NAACP and the great leadership that you provide and the way that you keep our community informed on these very important issues. As we look at the education system now across the nation, we are in a crisis. Please pay attention. We're seeing a lot of talk right now about curriculums not including the critical race theory, which has been around for about 20 years. We still have this reluctancy to deal with racism, and some people who actually openly admit that they think that slavery is okay. When we look at our education systems, our biggest problem is that we're focused on standardized testing instead of standardizing education. If we standardize education, then every child will get the education that they need with the proper resources according to their needs. When it comes to the Baker Act, school systems are in a dilemma, and I'll just be very real and transparent. Because of the legislation that is put into place by some people on the state level who vote for horrific policy that continues to sabotage the future of kids, especially Black and brown kids, we have a lot of rules and mandates. When kids do certain things now in school systems, we don't have an option not to arrest them because the law says that we must arrest them. So what some educators do is they find a way around arresting the kid and having them Baker Act. If they're threatening in school and they're acting out in an extreme and violent way, they sometimes result in Baker acting them instead of having them arrested. It is not an acceptable alternative, but it is one that we find ourselves being forced to utilize so that we're not continuing to arrest kids that don't need to be arrested. And unfortunately, when many of us went to school, we had like a paddle or a belt that would kind of help you adjust your attitude and your behavior. We don't have that alternative anymore. This whole act of Baker acting is real serious. And from a school's perspective, when it happens to students outside of school and they return to school, it's a major disconnect in what their treatment plan is, or if there is a treatment plan, because there continues to be a problem as to who should pay for their treatment plan. And we know that we live in the southern states, and Florida is one of those southern states who have failed to extend Medicaid and continue to create problems where all people are not properly insured and where people of color do not have proper access to the help that they need for health issues. And when I say health issues, I mean physical health and mental health. So this is definitely something that we must prioritize. I don't know if Madam President is going to form a task force, but we cannot sit silently by and watch this continue to happen to our children, both in school and out of school, without addressing it and supporting those legislators on the state level that are standing for justice and making sure that things are done fairly and right with our students. I will also take this moment to say that the Broward County School Board and the superintendent has planned a very robust summer school program. I really need your help in encouraging all the students that you can to attend summer school, even if they're not struggling. They have been out of school in a traditional way for about 15 months now, and we need to get them reacclimated to the school system in the right way. And we are planning to open school in August in the traditional way, 100% face-to-face. There's still a conversation going back and forth about where masks will be mandatory or optional. The board has not taken a position on that at this time. But please continue to prioritize our children. They are worth the inconvenience. They are our future, and they need our love, our patience, our tolerance, our grace, and our advocacy. Thank you, Madam President.
Jacob will be in school on Monday.
Well, we know that several years ago in Broward County, Superintendent Runcie commissioned a study to study the number of children that were in our schools that had disabilities and the resources that we had to deal with them. And so I guess I saw somewhere that a number of the children that have been Baker Acted or are being Baker Acted throughout the state of Florida have disabilities. And I don't know how that ties in here with the school system, but I'd like to hear from Dr. Osgood and then either Attorney Jackson or Attorney Boyd on when it comes to that. So Dr. Osgood.
Certainly, Madam President. When we diagnose many of our kids, we do find that they have various disabilities. And the way that the state gives us funds, if students are classified in certain categories, they do provide additional funding for those students. Within the school system, we have a very strong mental health component where a lot of our schools now have psychologists in the schools trying to meet some of the needs. We have behavior specialists in the schools, but there are things that we're limited to because we need parent consent. So another part, what we have to do, Madam President, is begin to just educate our community on how to love and take care of our students better that have special needs. A lot of our classroom environments, we try to mainstream our students because we don't want them to be singled out or to feel, indifferent in school. But it is a challenge and it is a struggle. It's one of the very, very difficult areas in education to address in the way that school systems are designed. School systems are designed for a particular group of high achieving students. There is not a lot of flexibility for students that don't meet that category. That's why when you get phenomenal leaders like Mr. Robert Runcie, it's very important that you support the creativity and the innovative things that they bring to a school district to make sure that equity is across the school district for all of our students. So in the days to come, as the school board looks for an interim superintendent and then a permanent superintendent, and I would just say very transparently that 6 of the largest school districts in the nation right now are without a superintendent, and Texas has been without a superintendent for 2 years. So translate, what does that mean in my rapper language? Translate, blah, blah, blah. It means that as a community, we're gonna have to level up and make sure that we are paying attention to what's going on in school systems as it relates to our kids, no matter who the superintendent is, no matter what the transition period is. But it is certainly an area of deficit that can be improved in the Broward County School District as well as other school districts.
Thank you.
The research we've looked at is that just as the Baker Act is applied disproportionately to BIPOC students, it is also applied disproportionately to students with disabilities. And as Sam pointed out, in talking about the requirements of the Baker Act that should be followed, but are often not followed and people are not even properly trained about, Unfortunately, people often inappropriately and illegally Baker Act students who have who are showing symptoms of their disability. And not only is that more harmful to that child, but it's also completely ineffective, because you're taking the child to a mental health facility. If there is not a mental health issue, it's really inappropriate to be in a facility that can only address that. That facility is not created to address the disability that is actually, the child has been Baker Acted for. So that's what we've seen, and that's the problem with it. Is those students need protection.
And Sam, did I hear you say earlier about it being illegal, actually, to Baker Act kids with autism?
It's illegal to Baker Act someone if their behavior is caused by autism. So, a child might have autism and also a mental health condition. But, if the reason, if a child has autism, you have every reason to think that they're behaving in a certain way because of that autism, it's illegal to Baker Act them for that behavior. Yeah, absolutely.
And so if you are a parent of a child with a disability, your child has a diagnosis, and he or she is behaving in the way that his or her diagnosis says that they will behave, and your child has been Baker Acted or is being Baker Acted, what is the parent supposed to do? What can they do?
So, first of all, I think, if the Baker Act hasn't happened yet, be very clear to everyone involved that, this is happening because of autism. I know that because of my experience with my child. I know the law. I know that that's not a valid basis for Baker Act. I don't want to promise that's going to work to stop it. It very well may not. And then you can, once a child has been taken to a facility, communicate that to the facility too. Try to see, when is that, really push about when is my child going to see a psychiatrist, because that's the only person, or in some cases a nurse, a psychiatric nurse. That's the only person who can let the child go. So try to push to make sure that happens as quickly as possible at the facility. And then if you have access to a lawyer, or if you can contact a local legal aid society, they can, or a public defender potentially, although I don't know that all public defenders do this work. They can file a writ of habeas corpus and get the child released. And that's usually just filing one is enough to get a kid out. And there are attorneys who specialize in that. But again, that's obviously not something that's available to everybody, and it shouldn't be necessary.
And for families, we have people on presidents from all over the state regarding that are listening. So within their area, if they have children who have been Baker Acted, what should they do? Who should they call to report it and to see what actions they can take going forward?
Yeah, there's not, unfortunately, a good list right now of practitioners who take on, Baker Act cases. If you look on sort of legal referral services, they may be able to connect you with someone. They're often Baker Act, Marchman Act lawyers. So I think that's, local bars are also an option for trying to find attorneys who have those specialties. There's also statewide bar referral services. And if you look specifically for Baker Act, they may be able to refer you to an attorney. Also, local legal aid societies can also, refer you to resources if they're not the right ones to be able to handle it. So that's as far as getting kids out. And Bacardi may have other suggestions as well. So please jump in if you can. And then I think the other thing is, when a child is released, just give them support, right? Try to find as many, understand that it has been a traumatic experience, and get them, whatever mental health resources they need. And then really importantly, go to the school and make sure the school is taking steps to make sure this doesn't happen again. If it's happened once, that is, absolutely, if the school was not on notice, the child had special education needs before, they absolutely should be on notice after. And that is work that local special ed attorneys and legal aid societies absolutely do, is making sure that schools are giving kids the services they need to get what's called a free and appropriate public education. So that's, what that means is different for every kid, but it absolutely should be the case that the school should be setting up a plan, usually an individualized education plan, to make sure that the kid is getting whatever supports they need, so that this doesn't happen again.
And if you, so yes, kids do get, assuming you're talking about IEPs. Okay. And so if you're a parent, I guess we're saying connect to care earlier. I can say that one of our judge, we have one African American judge who works in juvenile. I think it's 4 that had a concern over pre-COVID about the number of kids that were being Baker acted from the courtroom. And he just said he just couldn't figure out what was going on. And so I guess going forward, Judge, how does that work if I don't know if you're suddenly there and somebody makes a decision to Baker Act the child?
Normally, that's done outside the presence of the court. And that's how he was able to learn about it. Something happened in the courtroom. And when the transporters took the child in the hallway, the child was probably kicking, screaming, falling on the floor, doing things that children do when they're upset, when they can't go home with mommy and daddy. And so their only recourse, because they're law enforcement, is just to initiate a Baker Act, take them in. And before Florida, the Senate Bill 590, nobody was calling the parents. A lot of times parents were calling around, thought the kid had been either kidnapped or they ran away from home. Nobody knew. And it's, Judge Williams is in a position as a juvenile court judge to initiate the Baker Act because he's one of those 3 classes, either a judge, a mental health provider, or a police officer. But they normally wait until they take them from the presence of the judge, from the courtroom, to then initiate Baker Act. So they don't have to take them back to the jail because they're going to be a problem in the jail. It's just easier to take them somewhere else.
Dr. Osgood?
Yes, Madam President, I want to ask a question. As we are talking about this very critical issue, are there entities that provide training so that elected officials and other decision makers know what the law is, know what to look for, and can be better trained around this issue? Because it is something, being a person in recovery, I'm certainly, familiar with Baker Act. I would kind of run from the police so they could never really catch me, but it is something that's very critical that we have an understanding of, because when you're working in an organization, especially when you're dealing with students and children, you might not always know all of the laws or not be educated. I certainly over the last 8 years gained a wealth of knowledge about children and different disabilities and autism and all those things that I did not have before going to the school board, but I had to kind of seek those things out on my own. So if there are entities or organizations that specialize in the training, I know a lot of times you attorneys, you judges have a lot of information that other disciplines need, but most of the time we don't see you until there's a court case. So I was thinking as we move forward, even to just educate ourselves better and the community better around this, what is appropriate and what's not appropriate, because I know parents in my district, when they go into a lot of these spaces, they're dependent on the person that's there in that space to provide guidance. If we don't equip them with the proper knowledge where they can ask the right questions or respond in a certain way, sometimes they will agree to something because they don't know that it's inappropriate or that the law gives them an option not to.
So I think that was a question for either Sam or Bacardi.
Yeah, and I think Bacardi had to step away from her camera for just a second for a family matter. Yeah, I think that's a great idea, Dr. Osgood. And, I think we would have been talking about doing some of that ourselves. I think, the team at SPLC that's working on this is mostly me and Bacardi with some help from some other folks. So, our capacity is somewhat limited, but we certainly are interested in doing a lot more of that. And, I think we welcome any other organizations that wanted to work on it. It's an absolutely a need. And I think it's also something that, school districts should be doing as well, right? I mean, it should be part of training in mental health care, first aid. I think we've often seen, schools will do a ton of training on autism awareness or how to deal with, kids who have suicidal. And yet somehow, I think because there's a sense that no one really wants to take responsibility, and this is not a slight on anybody, right? But there's, police kind of think there's sort of some handing off of authority between schools and police. Schools say, well, it's the police's decision. The police say, well, really, if the school called us, it's not our decision at that point. I think at school police departments especially, I think there is a need for more awareness, and they may be trained sometimes on the law, but they're often not trained on the kind of traumatic impact that having a Baker Act can have. And that's certainly also something we can think about the legislation. Yes, Judge, please.
Judge Holmes.
Madam President, thank you. Mr. Boyd, I need the name of at least one or two attorneys who do the habeas for the Baker Act, because I'll get them down here and I'll get some lawyers down here to sit and I'll give them donuts, coffee, whatever they want to learn how to file those habeas petitions, especially for our children who are being Baker Acted in Broward County. So I'll take that initiative to get them on board. So if you're, it's Judge Holmes, RET@gmail.com. If you just give me a name, I'll invite them down and we'll have a training session on filing habeas. And I'll have the forms printed up. All they got to do is fill it out.
Yeah, that sounds like a great idea, Judge. I'd love to connect with a few of the folks that I know who do that. Unfortunately, the only CLE I know about on that currently is currently run by the Citizens Commission on Human Rights, and I don't know. It may be very good. I just haven't reviewed it myself, the details.
But you and I will collaborate. We'll get together on that because I need to protect this county, especially
Absolutely.
this county. So that's going to be my next motivation.
Representative DuBose.
Thank you, Madam President. I want to shift gears a little bit because I do have a question when you raised the issue about the IEPs. And I remember in the report, it talked about the implicit bias effect of children of color being misdiagnosed. I'm just wondering if Sam could speak to that a little bit and how, because we're having kids that are being illegally Baker Acted who don't fit fit that category, that criteria of mental illness, and then they're going in and they're being evaluated, and then we're saying implicit bias because we look at a little Black kid's temper tantrum as something different from a white kid. So I do remember reading something like that, and so I'm very curious as to how does all of that play into this, because I think that's another issue since we're talking about the bigger picture, how it can have a long-term effect on our kids who aren't even properly in this space, but if they're misdiagnosed, now they're tagged for the rest of their, school career.
Yeah, I think one way in which that plays out is, you may have a child who has some behavioral challenge, right? But the question is it being properly diagnosed in a lot of cases, and that can have a big effect on the kid. So there's actually a project being run out of the Centers for Autism and Related Diagnoses at, I think it's at Nova University in Fort Lauderdale, but I could be wrong about that. But it's the CARD Center for the region. They actually have a specialist whose job right now is to look at underdiagnosis of autism spectrum disorders in the Black community in Broward and Palm Beach specifically. And that's important because what happens is, if a kid is misdiagnosed, it's often not that the school just doesn't do anything, which could be good or could be bad. It's often that they get misdiagnosed, right? So they're often misdiagnosed with emotional and behavioral disorders. And those are the kids who are Baker Acted probably at the highest rate from what we can tell. So, when a kid is misdiagnosed as, with emotional behavioral disorder as opposed to autism, they're not going to get the supports they need to deal with their behavior. They might be placed in a specialized school, right, where it's going to for other kids with that situation, and that's going to probably worsen the situation. And so, and statewide, Black children are about 3 times as likely to be diagnosed with emotional behavioral disorders as white children, which is clearly an example of racially biased diagnosis. And so, I think it's both important to not overdiagnose children, but it's also important to not underdiagnose them. And I think probably both things are happening in the state. And what's really important is that kids get the care they actually need to succeed, right, or not, and whatever that is, right. And I think that's ultimately schools' responsibilities under IDEA and federal education laws. But if schools are not doing that properly, and I appreciate Dr. Osgood said they're not being given the resources to do that in a lot of cases. There's also advocates who can help help that happen, and that's folks who work for Disability Rights Florida, who work for local education or local legal services organizations. They all have units that do that kind of work. So I don't know if that fully answers your question, but that's yeah.
Representative DuBose.
Just kind of a follow up. So moving forward, I guess, I mean, there's the implicit bias and we could do the training and so forth, but you mentioned resources. So I guess if we talk about this on the legislative level, and we talk about, shaping policy but I guess there is a need for resources. Both yourself and Dr. Osgood mentioned it, but I guess we can talk about specifically what resources and where they need to go in order to have an impact on this issue we're discussing. So I just want to throw that out there as well. I know we're talking about policy, but if resources are a part of the solution, then let's have that discussion as well.
Yeah, and also, oh, excuse me.
Go ahead, Sam. Go ahead. Go right ahead.
I was just gonna say, I mean, I think it's also about how we're deploying the resources, right? I know spending more money in Tallahassee is always hard, but it costs money to Baker Act a child, right? And that's often being paid for by the state through the healthcare system. And I don't have a great sense. I would love if you have resources through the staff that can help us get at this. I would love to know how much it costs Florida to Baker Act all these children unnecessarily. I don't know the answer to that question, but I think it's going to be a lot of money, and that's money that could be better placed to interventions would be more effective and also less harmful.
I'm pretty sure that answers that.
Go ahead. I read somewhere that when the law goes into effect or at its inception, that school districts should have updated their policy to include the parental notification. So how does that really work when the policy, to Dr. Osgood, when school boards, is there a certain time of the year can that be implemented right away? Or is there because I know sometimes they say, well, we have to have, do a certain policy change sometimes of the year, but something like that where it's statutorily required. How will the two districts proceed in that?
So rulemaking is a process in the district. When something becomes law, there is a process where the policy is brought to the board and those changes are made. And when they come, and I'll just say Representative DuBose does a good job for us in Tallahassee, but oftentimes those changes come without the funding. They come as unfunded mandates. So when you try to implement those things, you can't implement them because you don't have the funding for the staff. And then that's another process, because now you have to realign budget items. You have to do a lot of shifting so that you're in compliance with the law. But whenever a bill becomes a law, then the school district has to go through the rulemaking process to bring the bill with those changes. And sometimes if those changes are substantial changes, you have to go through 2 or 3 readings in order for them to actually become the policy. But we have to follow the law. So when something becomes law, we don't have an option not to implement it, even if we don't always agree with the law the way that it comes down. But the more critical issue is there has to be a way that we can begin to talk about public policy in a real way, that when we create policy, we do critical analysis of that policy from an implementation perspective, that we have the dollars allocated to make sure that those policies are implemented and that the implementation is evaluated with some type of fidelity. If we get policies at the school board and we implement them, sometimes it's 4 or 5 years to know what kind of impact they're having, again, because you don't have the follow-up dollars for the proper evaluation. And what I've learned over the last 8 years, oftentimes those evaluations need to be done by some type of outside entity in order for you to get the true facts to find out whether the program is working or whether it's not. What we do is we normally just count numbers, and the numbers, the quantitative approach to the program does not always necessarily tell you if the program is effective or not. So when we set up evaluation strategies that are both quantitative and qualitative, where we're getting numbers, but we're also getting stories. We're having people tell us how this program worked and what's working and what's not working. It's how we're going to get to a true place of public policy that's really helping kids and not just blowing a smoke screen and then things are happening to our kids that you can't see in the smoke screen.
Well, I believe since it's statutorily required, and you all can tell me, I think it said that it had to happen immediately, and then it's just we talk about the parental notification part, and I don't know about, and this is a state piece, and I understand that, but I could say, Doc, in the district, for every disciplinary issue, the first thing that the matrix says is parental notification. So it's not something that's going to be, that should be out of the way, but I guess it's a matter of follow through. And I don't know if the policy has been changed or not, or if it's going to be implemented by the time, well, I guess kids are in school and they're going to be implementing. So
Yeah, when you say parental notification, so from a school district's perspective, that means that I could send a note home with the kid. Now I could send an email, but I don't have a way to know that that notification really got where it needed to get. With some policies, like when we want to make sure that kids have information, whether it's sex education or some of those things, we say that if we don't receive a response back from the parents, it opt the kids in. So you can send the notifications in a multiplicity of ways. But again, there's no confirmation process to know that that notification actually reached the parent. And then sometimes when our kids are living with different individuals, say for example, I may have a couple of kids in my district that may live with the aunt this week or a cousin next week, but the address that I have is the address that they started the school year with. So we have to send a notification if the law requires that when these things take place. But I'm just being transparent. When it becomes law today, it's not always today that the law goes into place because it has to come for the policy to be changed.
okay. Judge Holmes.
Well, Senate Bill 590, even though it's not everything that we need, the notification process starts with the school with a phone call. Because the child is already being taken away. The police are saying, we're taking the kid, and so the school has to begin, the principal or whoever, and it'd probably be wonderful, the person that called the police to start calling the parent, because you can't send anything with the child. There's no email or something or paper, and the statute makes clear, they want the number of times the notification was attempted and tried. They want to know who was called, how many times that person was called, because they're saying you got to make every effort to notify that child's parent or guardian. So that's a start. And it's something simple, it's phone call. But I'm aware that a lot of people have cell phones. They don't have hard lines in their home. They have jobs. They can't take the call. But you know what? That people have to just start making calls. And even if they have to stay beyond the time, because the parents should know, because a lot of times the parents are calling the police saying my child got kidnapped, didn't come home. They don't know what's going on. So the statute says we want notification, and you have to do everything in your power to notify the parent. And then the facility where the child is taken has to make some notifications. They got to call. We got Johnny here. That's the whole purpose of Senate bill. And then DCF is mandated by that statute to keep records, okay, of what who called and how the child slipped through the cracks. Because the only way that I'm going to be able to disperse our arsenal of attorneys who are going to be trained in habeas to know this, if the parent calls the NAACP, says my child has been taken somewhere, the school said something about a Baker Act or Mr. Baker or whatever they call it, we get the phone call, and we're going to start filing those forms, emergency writs for habeas corpus to get that child out unless there is a compelling medical reason not to get that child. But the school, I mean, if the school can call the police, that person in the school can start calling the parents, send emails, send text messages, do whatever they need to do. The facility is under a requirement to notify the parent, but we got to have good records. So I understand about a child going from aunt to aunt and uncle. We got to be able to track, and so maybe that will be a deterrence from the school making, at least the school. We can handle the school making the call. I don't know what's going to happen outside the presence of a judge in the courthouse, because the judge has no idea what's happening in the hallway behind his or her courtroom to know that that child is being Baker acted for acting out for what happened inside the courtroom. And so we just got to get diligent about this, because 37,000, that's a lot. I mean, over 37,000 every year. And you're right, the state is paying for it. And as a taxpayer, somebody's getting that money. Probably some privatized company is making a killing off of committing our children. So I'm passionate about this. It can be done. The law is supposed to take effect on July 1. And also, Senate Bill 590 does do something that just makes my heart leap. I hope nothing happens between now and July 1st. But they also recommend to the police officers to issue civil citations to the children.
Right.
I'm praying that that's a backup for 985-12 for civil citation. So we got our work cut out for us, but we gotta at least start somewhere. And if the schools feel, teachers feel we can't be making these phone calls, then don't call the police. Okay, and y'all can get that message to them. Y'all got behind the scenes ways of getting these internal communications. If you're gonna call the police, you better get ready to start calling mama and auntie and uncle and them, all of them. Somebody needs to be notified that this child is being taken away, because there's got to be some remedy here. But I will say to you, Representative DuBose, maybe you should follow that money for us. See who's making a killing off of 37,000 children every year, going into a Baker Act facility. That's when I saw those numbers, I thought it was a typo. But it's on too many pages in Mr. Boyd's report for me to think that he made that same typographical error. So Sam has just told me, almost all the Baker Act facilities in the state of Florida are privately owned. Okay, so I just found out that answer.
Well, Judge Holmes, I made a note earlier to find out exactly how much it costs to Baker out the child, because if I haven't learned anything else in this process, I've learned with all these issues or problems, you start by following the money. It's very unfortunate, but if we gonna keep it real, you start by following the money. You follow the money trail and a whole lot of other answers will open up. So that's something we gotta work on. We all got homework. And we know where it's going, right, Sam? You say they're all private. So
and Ms. Jackson says sometimes they keep the children beyond the time that they need to be in there. That's 72 hours because they're making money. Hand over fist money.
Yeah.
Let me just jump in.
Find out how much it costs.
I responded to Madam President's question. I responded based on parental notification across the board. We have it in a lot of areas. We have police on campus, SROs on campus. So the police is present at schools. The calls I receive around Baker Acts, probably about 4 or 5 times a year from parents, is the fact that they are at the school and the child is being Baker Act and the child is not crazy. They don't want them to go to these places. That's the response that I get. I will go and pull the Broward County school data so that we can have accurate data to be able to see why kids in Broward County schools are being Baker Act. I know that those numbers have increased because I recently had this discussion around how we're responding to all of the things that we got with 7026, if a kid brings a gun, whether it's real or not, and some other laws where the law says that I have to call the police, that they have to be arrested. So I've had some conversations with some individuals on school campuses that I won't name who have used the means of Baker Act to keep the students from going to jail. But we are calling parents, and parents sometimes respond in an adverse way because they don't want the child to go to the facilities. And sometimes they're correct, but there are times when they do need to go. So I'm not suggesting that the teachers or the principals are not making an attempt to do their job. I'm sure that they could do a better job in some cases, but I will be very, frank. Mr. Runcie's policies and procedures and what he's asked the board to implement has been to stop streamlining our kids to jail, to mental institutions, and to those things that's going to have an adverse impact on them. And just like any organization, when you set policy, you still have people within the structure who don't want to operate in the way that you're trying to get them to operate. But my homework assignment is to pull the specific data so that when we're talking about Broward County Public Schools, we have the facts, we're able to identify where our issues are so that as a community, we can address them.
Thank you. And could we, Doc, could we drill down to the data so that it could include the schools and also the teacher and the law enforcement agency and who is actually, and the principal who's actually where this is happening? And I think that will be very revealing because usually they just got one answer for us. And oftentimes it may be a specific teacher. The kid may do well in other classes, but this particular teacher or school leader has a different way of dealing with children. And I had a question for the attorneys. So I know that when there is an arrest, the officer makes the decision and is at his or her discretion. What about when it comes to Baker acting? Once a school leader contacts law enforcement, and is it the school leader who makes the decision to Baker Act? It is the law enforcement, and if they decide, I think that we're going to do this, does the school leader, can anyone intervene and say this is not what we want to do, or is it totally up to the law enforcement officer?
There are only 3 sets of people who can Baker Act, and that's a judge, police officers, or a mental health professional. And so unless there's a mental health professional on site at the school, the only person who would be there with discretion to Baker Act would be the police officer. The problem is the police officers don't have the same standards by which they have to, or same criteria in order to Baker Act a child. So their criteria are actually lower than the criteria for a mental health professional to Baker Act a child. They can do it based on hearsay. They don't have to have any kind of certification that that they've observed any behavior. So police officers can even override mental health professionals when mental health professionals, and we've heard about this, have said this child does not need to be Baker Acted. And so that's a problem with the legislation that needs to be corrected.
Okay.
Representative?
No, that's a good point. I was going to ask a question before she said the override that the police officer would have. And I know Dr. Osgood is saying that, in the district, we have more mental health professionals. And I was just wondering early on with the conversation, and we're talking about the trauma piece, is it that the police officer is the only person that could transport the child to these facilities? I mean, even when it's legit, it's still, it's trauma. It's still, like you said, being arrested in a slide. I don't want to go to jail and all this. So it's not like I'm going to a place for help. If this child is legitimately diagnosed and checks all the boxes, does the police have to be the one to transport them to the facility? Because
I would say normally that's the personnel that have the cars and the screens. Sometimes I've heard of ambulances being called, and they wrap the child up in the straitjacket and take them. But I think the reason why, going back to Ms. Jackson's answer, the reason why a lot of the facilities just cower to the police, because if the police bring them there and say, we're not putting them back in the car. They're not under arrest. I was told to bring them to your facility, and I'm leaving them here with you. So that's, and the facility is not going to have that liability of saying, And I don't even think they're thinking of liability at this point. They're thinking of the money that they're making. So that's why the police seem to have that type of authority when they say, I'm not transporting them back. I have nowhere to take them. I'm not taking them anywhere. So they drop them off. So it's a money thing, but police enjoy a lot of qualified immunity. We haven't discussed that because I know that everybody's thinking, well, why haven't they been sued? Because if they're acting under 394, that's the statute, then you'll be hard pressed to say that they were doing something else other than that. And so you'd go to court, federal court, and under Rule 12B, it would be dismissed.
There's a question.
Some people, Miss Hosley, I know you said you sued them under 1983, but how many cases have been successful under 1983 for Baker Act? For excessive force, that's a very powerful statute, federal statute. But for Baker Act, do you have any information on that, Ms. Hosley? You can put it in the chat or the Q&A.
Okay. And Ms. Burrows, Sonia Burrows has a question. If a parent is contacted and says they don't want the child sent to a facility because the child has a disability or is autistic, why can't the parent come pick up the child? Any of the lawyers?
Mr. Boyd?
Sorry, I was just making sure I read the question. Yeah, I mean, so I think certainly the parent should be allowed to come and take home the child. If the school wants to do that, that is totally within the school's power to do. It does not have to initiate the Baker Act, doesn't have to contact law enforcement if it doesn't want to. And I think to the extent that the law enforcement officer works for the district, the district can.
That depends on where they are.
Exactly.
In Palm Beach County, they work for the district. In Miami-Dade, they work for the district. In other counties, for example, Broward,
they don't.
The majority of them in Florida, they don't work for the district, and they will say that very quickly. I don't work for you.
Absolutely, but I think also the extent to which police are involved in mental health, evaluations could be a subject for bargaining when the contract for SROs is developed, right? So schools do have tools to figure out which resources they want to deploy towards kids in mental health crises. But obviously, there's a lot going on in those negotiations, I realize too. So, but once the examination has begun, once the officers filled out the paperwork and transported the kid, then only the facility can let him go, and only if a psychiatrist signs off on it under current law.
Are there any policies that you know of, Dr. Osgood, when it comes to initiating Baker Act or interacting with police to move in a different direction rather than Baker Act?
Well, if the mental health professional is saying that the student needs Baker Act, the principal and the teachers defer to the mental health professional. When you're in a situation in a school and a law enforcement officer is present, no matter what the law says, the law enforcement officer kind of takes the more authoritative role because nobody wants to get into confrontation with law enforcement. So we try to leave those decisions to the mental health professionals. So they're guiding those decisions. Sometimes when parents are called and the mental health professional is saying that it's needed for the child to go for the Baker Act, sometimes the parent is not in agreement. And at that time, the parents can choose at any time to take their kid or to remove their kid if they have not committed any act of violence that quote unquote can be defined as some type of crime.
And I don't know, I guess to the attorneys, I know that there are laws dealing with children with disabilities when it comes to arrest, suspensions, expulsions, but you're saying there is nothing when it comes to Baker Acts?
Not state law. I would certainly argue that, federal anti-disability discrimination laws, the Americans with Disabilities Act, those certainly apply to the Baker Act as far as we're concerned. So if you're disproportionately doing something bad to people with disabilities, that can be, that's not necessary. That can be a form of discrimination. And we do think that that's a real problem that schools should be thinking about seriously.
Okay. Let's go to the chat and see if there are any other questions before we begin our wrap up. If you'll do that, Judge Holmes, to make sure. And so what we're going to do is we are going to have, I guess I will have our NAACPers contact me, and I will forward that information on to you if they want to talk about their experiences that they've had throughout the state as we move into our next step. Because it's not just happening, and we're talking about Palm Beach County, but obviously we know it's a problem across the state. And one other thing, Judge, you said the new statute talks about issuing them a civil citation, but why would you do that? Why would a person do it? One of the worst things we could do is open that door, and it's like it's already been open to prove civil citations in our schools, because that's, it's pre-arrest, but civil citations do go into JJIS. And so if the child is exhibiting behavior, particularly if he or she has a diagnosis and that they're going to behave, why would we issue a civil citation to a kid who may be in crisis or is not, or even if he's not acting out but not violating statute? So why would we issue that child a civil citation now? There's an overusage in Orange County for everything. If you ran in a hallway, they started giving civil citation, and there's you just can't. They're not going to keep giving you civil citation of building up to arrest. So I don't think I don't think that would be a good idea. We have done our very best, along with Dr. Osgood's help, to keep civil citation out of our schools, and only as a very last result if the child was going to be arrested. But I think I thought I heard someone that when a child is in crisis, they may not very well not be arrested or accused of committing a crime. They are in when they're taken to a facility. So we have to be very careful with that civil citation piece, because that says that they've committed a crime.
I brought that out because that's in the actual legislation.
Well, can I just say that it's a bigger bill. It's the school safety bill that the Baker Act language was in, and which it should be a standalone legislation itself. But again, we start out that way, but we end up sometimes having to be a part of a bigger piece to just get things started. So when we move forward, we will start in the vein of having it as its own legislation where it stands alone. It doesn't get caught up in. But I think, and Judge Holmes, correct me if I'm wrong, I think in the school safety bill, it actually provides that students' participation may not be entered into JJIS.
Yeah, it's excluded from JJIS.
Yeah, so that's, I guess that's another good thing. But the problem is when we put all this stuff together, and then again, as I stated, we pass legislation, but it's a lot of times it's up to who interprets the legislation. And we mentioned implicit bias and all those different things. And so people start drawing bits and pieces. So it should not be together. So we should not have this issue. We shouldn't be having this conversation together with this. So, but I just wanted to point out that part that should go into JJI.
Doesn't that violate single subject? The
Hey,
single
and back in 2014, when I was a freshman, we actually had some challenges there. But since I'm on my way out, and my 7th session, I don't even think that exists anymore. I mean,
not with this current Supreme Court. It doesn't. Not with the current Supreme Court of Florida.
Ooh,
but there is a question that I think Ms. Jackson and Mr. Boyd may want to ask. Are certain demographics taken under the Baker Act at disproportionate rates? For example, foster care, children of color. If so, is there a source of truth to view these statistics? And I think your study, Mr. Boyd, found out that foster care children, they get medicated, injected just because they're in foster care as opposed to other children. So if you'll speak to that question.
Yeah, absolutely. And I don't have the exact numbers on that, but it's really, I mean, they're the most Baker acted children in the state, our children in care, because they don't have, in a lot of cases, unfortunately, folks who are advocating to keep them out, right? Of those facilities. And there's also, and this is more anecdotal, but from what we've heard from foster care advocates, what often happens is a kid will have a crisis. They'll go to a Baker Act facility. Their existing placement, if it's a foster home or a group home of some kind, won't take them back. And DCF will just leave them in a foster care facility until they have another place for them. And that can take weeks or in some cases months, which is definitely not legal, and yet happens pretty regularly.
I mean, in a receiving facility, that's where they could be left.
Yes.
And Judge, I think one of your former colleagues had something to say in there. I think you know that.
I see in the comments, Judge Afric Ellison wants to know how it can. I'm thinking about that, Judge. I'm not sure you in the dependency realm have a say in this, but to the extent that I'm now thinking about it, I'm getting everybody that I can involved, especially Broward County. I'm gonna be like the Tasmanian devil. I'm coming through. It should not be happening to our children. So I'll keep in touch with you, Judge, and to the extent that if I can work a piece in through dependency, your name is the first name on my list to contact.
Thank you. All right, we are gonna begin our wrap up if we've answered all of the questions. And I think we have. So
Jasmine has her hand raised.
Okay. I'm sorry, go ahead, Jasmine.
Yes, there's a question in the QA, and it is from Dr. Jennifer Williamson, if that can be addressed. And it's with regard to certain demographics that are taken under.
That's the one she just read. Yeah, they just answered that one.
Okay, thank you very much.
Yeah,
thank you.
And of course, Black and brown children are disproportionately represented in the 37,000 plus per year that are Baker acted, so we're going to be working on that too. But we now know why. There's incentive to Baker Act our children. It's like 13 all over again. We're going to make a movie called Baker Act 13. So the 13th Amendment allows for the servitude, and so Baker Act allows to put them in and make them, give them tickets basically to the prison pipeline. So, so we're working. I'm so happy for this, Madam President. I'm going to turn it back over to you. Those were all the questions in the chat. I think Jasmine was monitoring the Q&A, but that same question was in the chat, so that's why I asked. So Jasmine's hand is still up though.
Okay, Jasmine, did you have another question? Okay, down. All right, so we are going to wrap up here, and we will start. We'll go. Let's hear from Attorney Jackson. And you're speaking to NAACPs across the state. What is your next step for us? A lot of our leaders are on from the Panhandle all the way down to Miami-Dade. So what is your instructions to us, thinking about our partnership and how we're moving forward on this project?
Thank you so much. Really, really happy to have a partnership with NAACP. We have been always in touch on so many of our issues that we work on. For this particular issue, we think it is really, really important for people to be informed and educated. We would ask people to share information that you have. I've dropped in the chat the link to the report that we've worked with a number of partners on, and we would urge you to share that broadly. It's important to be informed for the discussions that come up in legislation. Unfortunately, as you know, Judge Holmes has pointed out, there is an incentive, and there are people who are very loud and making their preferences known in legislation, and there need to be counterbalancing forces speaking up in Tallahassee for our children, not for the profit interest that stands behind the receiving facilities. We would also, urge everyone to support children and families and to be vigilant in your own communities and school districts. If you do see this problem, we would love to hear more about it. We are looking at, as I mentioned before, litigation, we are starting in one county, but we are moving across the state. We do intend to address this in whatever means is necessary to stop it. And we are representing individuals as well as organizations. So please feel free to reach out to us, and we thank you for your time.
Okay, thank you. Attorney Sam Boyd.
I'll just echo Bacardi's remarks. I don't really have anything to add, but really appreciate you giving us the time to be here and to talk about this.
Thank you so much. Representative Bobby DuBose.
Thank you, Madam President. And this has been very informative to me. I think, again, I'll just reemphasize that we are in the right posture to move forward. But I will add to those that are listening and presidents of other branches throughout the state, please reach out to your elected officials, have the conversation with them based on what you've heard and learned, and be ambassadors on this topic. And I say talk to all of your elected officials, regardless of what side of the aisle they're on, because this is not necessarily a RRD issue. This is an issue about all our kids, and make sure you hold us accountable. This is where it starts. So we all have a role to play here. So I would encourage everyone to make sure you reach out, because I'm telling you, on my side of the equation as a Democrat leader in the House, this is a priority for us. So I need you to activate, and we need to make sure. I would also say too, to Sam and Bacardi, if you can maybe do this presentation to the NBCSL, National Black Caucus of State Legislators, and also to the State Black Caucus as well, and make sure. I think this is something folks kind of know about, but not necessarily understand the intimate details and understand how it's more effective, how it affects a lot, and it has a larger impact and a much wider footprint than just a single act of Baker Act and the things that we discussed. So again, Madam President, thank you for putting this together, and we got work to do. And I will say to anyone listening, anyone on this panel, please feel free to reach out to me so that we can collectively push this thing forward and make sure that the next legislative session, this is one of the priorities that we continue to push forward.
Thank you. And our own, well, actually everybody's school board member in Broward and out of Broward, quite frankly, our own Dr. Rosalind Osgood.
Yeah, Madam President, thank you so much for this forum tonight. Thank you to our presenters. And I'm going to ask that you reach out. There are entities that represent school boards, like the Florida School Board Association, the Council of Urban Boards of Education, and the Council of Great City Schools. And you never hear this kind of stuff talked about in workshops and things that they're bringing forth there. We cannot continue to allow those institutions to not engage in these types of discussions and provide information and education that's going to help children that look like us. A lot of times these subjects are kind of just left out of what they're teaching and what they're talking about. I'm also going to echo my big brother, reach out to your school board members. I'm one school board member in Broward County. It takes 4 other votes to get anything done. We have to hold people accountable that represent us. If you have a district school board member, even though that person may not look like you, they have a responsibility to hear from you and to have conversation and to represent your interests. A lot of times we don't do that. We just kind of go to the one person instead of the person that we're able to vote for. And it's very important when it comes to our children that we touch all entities. I'm hoping, Madam President, we'll be talking to the Children's Service Council. They might just have some money. They get a lot of money to help kids in Broward County. Maybe we can send Judge Holmes over there, to get some money from them so that we can train and do some things around this issue. We have a lot of entities that receive a lot of dollars and they run numbers and saying the impact that they're having on our community. but they never address these critical issues like this that will really help our students and help our families. So thank you again, Madam President, for your leadership. Thank you, Judge Holmes, for your counsel. I'm so glad you didn't retire for real. And it's always good to be in the presence of such esteemed attorneys as Attorney Boyd and Attorney Jackson. Thank you.
Thank you, Dr. Osgood. And last, certainly but not least, our own branch's general counsel, Judge Alona Holmes.
You know, after we have these town hall meetings, I get a phone call. There's always something that this, our president, and I've said this over and over again, I've never seen anyone more tenacious about protecting the rights of our children than Marsha Ellison, who is our president. And because of her tenacity and her passion for the children, and I kept telling her, I said, I was never a juvenile judge. I didn't do juvenile work. I have become so proficient now in what's happening with juveniles. I might as well just stay on the bandwagon, but we're going to take care of these things. We're not just going to talk about these issues. The Southern Poverty Law Center, you certainly are going to have my assistance in whatever I can do. And, you know, Sam and I are going to become BFFs. He's going to be my new best friend. We're going to learn how to do habeas. Lawyers in Broward County, if you're interested, my email address is on the Florida Bar website, but you can type it up tonight. Judge Holmes, all one word, JUDGEHOLMES, RET. That stands for retired. Can y'all talk to the president about that? No. At gmail.com. That is Judge Holmes, RET, at gmail.com. And if you're an attorney and you're on this line tonight, and Bobby, I just got a text, Yvette DuBose, I think you may know her. She's offering whatever help and assistance that she can do. I know she loves children, and she's over at the Children's Heart Gallery. We're going to get it right. It may not happen in a month, but y'all know I don't like long-term engagements here. You know, we can get it done, we get it done. And I put the time clock on it. So we're going to make sure that Broward is covered, and then we will definitely, you know, cover other parts of the state. But let me just say this: if you are not a member of the NAACP, you really should join. If you've enjoyed, I mean, these town halls about civil citation, about Baker Act. And we've got other things. We just read reports where police dogs are being sicked on children and adults. I know President Ellison is really concerned about that. We're going to get involved with that, but we need you to help us, right? And so NAACP.org, and you want a branch 5099, and that's NAACP.org. And when you put in your information, they'll ask what branch you want to be affiliated with, and you can put 5099. Those are not the winning lottery numbers, but perhaps they should be if you join. So join us, help us in this fight. And I'm just enjoying, because I'm from North Philly. I love a good fight. So Madam President, back to you, and give me some more fights.
Okay, thank you so much. And one person who was unofficially on our panel, because she works behind the scenes day and night, and I'm not asking her to speak, but I want you all to tell that Pamela Birchford is great. She is the hardest working woman I know. She works with us, and she's just incredible. I mean, anytime that I have questions, you know, I had to, I've never been deposed before, and she said, "Oh, don't worry about it. I got you." And so it was a federal case for Amendment 4, and just Pamela was always a phone call away and making sure that we were prepared, that everything was fact driven, and we have some other stuff that we're working on as well. As I mentioned earlier, I am chair for the Civic Engagement Committee for the Florida State Conference, and I will be representing us in our other lawsuits as we continue on. in this fight for justice in the state of Florida. And I want to thank everyone for working, for attending, everyone for working with us, those who have not joined yet, but you're going to. And if you're not local in Broward, because we have people all over the state that will join your local branch, wherever that may be. You would just need to put in your, I think your zip code and your address, and they will direct to NAACP.org. Will direct you to your local branch. And so we want to thank you for being attentive. We are going to be, this is more than just a town hall where we just talk about it. We are going to be about it. I see the presidents that are on. You will hear more about this at our quarterly meeting on the 26th. And so we will make sure that there's follow-up and give resources and direction as we continue on. And having said that, we're going to, Representative DuBose?
Madam President, I just, maybe 30 seconds. I just want to echo your sentiments about Pamela Birch Ford. And she has been a resource directly for you all, but she has been an outstanding resource for us in the Florida House Democratic Caucus. And she has worked with us, and this partnership has been amazing this session as we fought some of the worst spills. I call them Jim Crow 2.0. And so I just had to let you all know when we talk about this fight being long-term, the partnership has been amazing. She has been a huge resource for us. We call her on the weekend. She told me that she has conversations with my leadership team that I'm not even aware of. And she has been there. She speaks to our caucus. And I mean, her work, her passion for what she do represents the NAACP in a huge way. And it helps us to do our part so that now, Madam President, when you are up to bat, you will know that everything's in the proper posture for you to knock it out of the park when you go to court and challenge these egregious laws. So I just had to say it.
Okay. Pamela, can you just say hi or say something to the people? I mean, to our state conference member, this is Pamela Birch Ford, who you all hear about all the time, but this is she. Go ahead, Pamela.
Thank you so much, Madam President. Let me say thank you to you, first of all, for your leadership, President Misuse, who I know is not with us, for partnering with SPLC and allowing this groundbreaking report to be presented this evening. This is a problem that we must tackle. As Dr. Osgood stated, it is a multifaceted problem. It needs a holistic resolve. And it's going to take all of us to do that. It has been my greatest pleasure to work with the NAACP, to work with Bacardi and with Sam on this issue, and to work with Representative DuBose in the Florida House. He has always been accessible to me, particularly when I want to discuss issues that are relevant to the NAACP. So I look forward to continuing this fight. Thank you so much.
Thank you for all that you do, all things big and small, Pamela. We appreciate you. And with that, we're going to close out as we started, decent and in order, with our own Judge Holmes, if you will do that. Judge, you're muted. Go ahead.
I talk to God all the time on mute. Father, we thank you tonight for this meeting. God, I thank you for the information that's been disseminated amongst your people. And God, as you said in Habakkuk, write the vision, make it plain that those that read it may run with it. The vision has been written to stop having our children Baker acted. Those of us that have read it, we are prepared to run with it. We ask you to give us the strength, the fortitude, the knowledge, and send help, send laborers into the vineyard to make this possible. Bless our leader of the NAACP, Marsha Ellison. Keep her strong, keep her mind, God. In the name of Jesus, I pray for all of our good health and our wealth and our success. In Jesus' name, amen.
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 Thank you, everybody. I appreciate you.
Right.
Good night. Good night.
Good night.